Hello and welcome. I'm Jai Changlani. I am the owner of Orb 360 Franchise Consulting. And today we've got Alistair, who's the director of ASCO Legal. And he's here to talk about the legal nuances of franchise. So with that, I just want to have a conversation with Alistair and see how we can work together and help the franchisors and franchisees. So over to you, a bit about yourself. What's your background, Alistair?
So myself, my firm, we've got a very strong background in franchising. My prior partner actually sort of co-authored the FANS has got a set of code of ethics, and he was a founding partner of FANS when it was set up in 1994. And the firm has been a part of FANS since then. So we've got a very sort of strong history in franchising. I personally enjoy franchising. There's a lot of benefits for franchisors and franchisees. Franchisees get the benefit of scale. They get a structure and a system around them to help them operate safely. And franchisors get the rewards from, the time and capital invested in setting up a system.
Oh, fantastic. Look, Alistair, this is actually a privilege to have you here today because I know the kind of work that you do. We've engaged with you in the past and we want to engage with you more in doing more work together. But I think a lot of this audience who are listening to us, they have sometimes don't know where to start from. Normally I get a first call, so people call us because I'm an accountant as well. Yeah. People will come along and say, look, what sort of... Am I ready for franchise? What do I need to do to be ready for franchise? Mm-hmm. And what are the documentation or how do I even get started in the franchise thing? So what I start off with actually looking at their finances and see whether the business is franchisable or not. Mm-hmm. Whether they actually, there are key areas such as your sales, your gross margins, your bottom line. Are we achieving those ratios? And then the conversation starts, okay, then how do I actually go ahead and take this further? What sort of lawyers' role is in deciding this? So where do you think the legal side of it is involved in this process?
Yeah. So you make a very good point. I mean, the first step normally in franchising is, as you would advise them, is that they would set up a concept store. And run that probably for a couple of years to get some good financials to see what it would run as a franchise store, because any prospective franchisee is going to want to look and see that the business model is financially viable. Having the legal stuff sorted is great, but if it's not making money, you can have the best legal structure in the world, just not going to work. So we normally get franchisors coming to us at that point in time, looking to set up a system. We're very fortunate because I co-author or contributing author for the precedent for a leading New Zealand publisher. So we update that for them every 6 months. So that means that we've got a very good in-house set of precedents to make available to our franchisors. And a lot of the time when we sort of see on the other side, the documents are very familiar, and that's because we drafted them. So they'll come to us, and I guess they're always very uncertain as to what's required. And as you know, there's quite a long list of legal precedents. There's a few that we'll talk about that are sort of the more meaty ones, and there's a lot of finer detail in those drafting that's required. And then there are others where you need them for compliance purposes, but they're probably not as sort of key to the system. And you don't have to have all the precedents straight out of the bat. It is something that you can develop on an as-need basis.
Awesome. Like you're right. I think, so, a lot of people would come along for the concept idea, or it's a concept store, and they ran it for few years, and they start under the branch. And a lot of time people will come along and ask me, okay, Jai, so what sort of options do I have, growth opportunities? Do I actually go and open another store, take the risk, borrow money from the bank, or do I do some kind of joint venture with another party who can bring some money in, or do I go and think or consider a franchise where I can have my brand, the value of my IP, which I can sell it, give it to somebody to use and charge some royalty towards that, or go back and look at options such as licenses. So a lot of people will come along with a lot of sort of unknowns, or because they don't know, right? At early stages, we do financial modeling, and we look at what the numbers looks like. On top of that, we prepare those documentations as well, which is preparing franchise manuals, operation manuals, different procedures and policies, which is needed for the franchise systems. But the initial question of what is right sort of structure, or which way they should go, there's always the question around license and and franchise. What do you think? What's the main difference between license and franchise?
I get asked that question a lot, and I think you the expression tomato, you say this the same thing in a different way. The way I think you would sort of look at a license is think of a color spectrum, right? And a B license would be on the one end of the spectrum, and a full format franchise would be on the other end of the spectrum. So in McDonald's would be a full format franchise. They pick your site for the land, enter the leasing, build the property, provide you staff, the food, everything. You basically rock up and manage. Where B license would be, look, I've got this brand that's known. You've got the right to trade under this brand, but you basically source your own product. You run it yourself the way you want to run it. Don't run my name into the ground, but you can do what you want. So, and anywhere in between where it crosses from calling it a license versus calling it a franchise, it is a grey area. From a legal perspective, there's no difference. It's just depends on the franchise agreement, I guess. And that's the journey we go through with franchisors saying, well, what do you want to provide them? What level of support? Each system, as you know, would be different. Different systems allow for different sort of levels of support and services. And we make sure that the legal documentation reflect what they're going to provide and what they're not going to provide.
Oh, fantastic. So really cool to know the difference, because a lot of time people will come along with that sort of mindset of saying, oh, maybe service is more license and product is more franchise. I've seen a lot of franchise service business as well. Like cleaning businesses, which are very known. A lot of accounting, small business accounting, franchise kind of model, which is already there. And there are other small businesses which are service-based businesses, which are also a franchise business. What typically I've seen in license is like you have a term of a license, which is like 3 or 5 years, and then you have a right to renewal of license for say two rights to renew that license. And there are tax advantages to do that as well. So if you do a license, then what happens is the entire amount that you pay can be amortized for tax purposes and treated like a depreciation, same as that, which means that you can claim the whole lot. With franchise initial fee, there are rules around what you can, what you can't do, and there is also something called fixed life intangible property, which is a specific rule around in tax that deals with the license and franchise. So there's quite a bit of difference in terms of how the tax treatment is involved. So if anybody's considering doing license versus franchise, I suggest you do talk to your accountant and get some opinion on that in advance. So that they can know which path they can go to. I have seen, from my experience, that a lot of overseas, people who are entering into New Zealand market from US and Australia, they'll have a master franchise model, not license model. But local businesses such as that have a manufacturing unit on the side, and they're developing the like a central manufacturing, and then they're licensing out for people to take the area so that they can sell, like a sales consultant who can become a license. So I've seen that. Have you come across much of that sort of businesses which does that?
So again, I think there's probably a bigger distinction clearly from an accounting and tax perspective. From a legal perspective, the label you put on it really means very little. In terms of territories, yes, franchisors and licensors, if you want to call it that, The reason they sell territories or licenses for territories is it gives them something tangible to charge an upfront fee for. And look, that upfront fee, to be fair, goes towards recovering the cost of setting up the system, which can be significant. Yeah.
You're right. I think, and that's right. A lot of time, the cost can be bit to start with, but by selling one or two areas or franchise, you recover pretty much most of the cost.
Yeah.
And I've seen, from my experience, and appreciate yours as well, that franchise business, being a sticky business, that means royalty that comes in every month on sale. Once you get into a decent size, which is say 10 or 15 outlets or franchise outlets, then you automatically quadruple or significantly increase the value of the business, because the people who are looking to buy such franchise, which is either a private equity funders or virtual VCs that are actually interested to buy such franchise, they always look at a big multiple of that based on what kind of royalties you've got, what kind of retention you've got with your franchisees, and how do you make sure that we look after the franchisors look after franchisees for a long term, because it's not really selling the the franchise area, but also making sure that the value of the entire brand significantly goes up when you have a long-lasting franchisee on board. Have you seen much of that from your point of view?
Yes. I mean, one of the things we look at if we're advising, let's say, a franchisee looking to go into a system, is we say that in any system you have franchisees that are surviving, you have franchisees that are thriving, and some are in between. And good systems have most franchisees thriving and very few just surviving or not surviving. Where poor systems seem to have a lot of franchisees not quite making it. And what you see then is you see churn coming through. So some franchisors don't realize that the value in their business is their franchisees, and the supporting their franchisees supports the business. So a good franchisor understands that. And franchisees do talk, and if they support the franchisees and help them succeed, it's a way of growing their business really successfully.
Right. Now, just looking at some of the documentation, and I know you're absolutely fantastic in terms of what you deliver in preparing those documentations. I've seen your work; it's really, really good, and you're very practical as well. So I've seen your conversations with me as well, very practical in terms of making a layman understand a complex legal document. So for your viewer, for my viewer, can you please explain what is this franchise agreement, and what's an important of having a franchise agreement done and prepared by a specialist like yourself?
Yeah, very good question. So the franchise agreement is probably the most important agreement of your entire suite of precedents that you'll use as a franchisor. It's the founding document, the relationship between you and a franchisee. It sets out all your rights. You understand, as a franchisor, you've spent a lot of money developing your system, and so you really want to make sure you protect your IP. So those are the tools you want to probably put in the bottom drawer and never have to use, but you're going to end up having to use it. So it gives you rights around entering into the business and managing it if the franchisee's unwell or they've just stepped out of it, because you've got to protect your brand. It talks about your ability to charge a franchisee, how they to manage it. Do they have to be on the ground? Are they allowed to appoint a manager? Training rights and obligations there are. So what's very important is to make sure every business, as you'd appreciate, or every system, is different in some way. I mean, yes, you get industries like food and beverage generally has the same sort of components. You've got a premises you lease, you've got people you employ, you may have multi-site franchisees, you may not. But even then, it's got to be sort of customized to sort of provide for how their franchisor wants to run their brand and the options that they want in the agreement. So, I mean, the way we work is we don't charge franchisors for the use of our precedents. They can have them, but good luck to them. What we do is we only charge for the time it takes to customize it for their system. And the more time we spend in customizing it, the better the outcome for them is down the track if they ever do need to pull it, which they will at some point out of the draw to deal with a franchisee who is looking to just rebrand and do their own thing. Well, great, we've got some restraints of trade there. Looking to sell to another party, well, we've got rights of preemption necessarily, so the franchisor can pick it back up if they want to before another party can pick it up. So it's a toolbox, and it's very important that you've got the right tools in your toolbox.
Fantastic. I think what you actually just said is so important, isn't it? Because every franchisor, every business is slightly different. Even the same industry, and I've seen that. So recently I'm actually acting for developing documentation for a cleaning company. So, and I've done another cleaning company in the past where it was doing residential cleaning. Now this company is absolutely completely opposite to that because they do only pubs and high-end sort of cleaning. And the requirements for what they do as compared to the other business that we've acted for, it's significantly different. Even though they're doing the similar sort of job, it's quite different in terms of what they want, what the expectations are. And I can see that, having an expert like yourself around who can take care of preparing those franchise agreements would be absolutely needed for them to achieve those goals for themselves and making sure they don't trip with the legal issues, if it's not been done correctly. So it's best to take advice, and it's best to make it customized, as you said, because the need and the requirements of every single business would be slightly different, in my view. Yeah. And now coming back to some of the, touchy topic when people talk about, this Privacy Act and disclosure documents and trademark and all these things, what sort of, is it really needed? How do we prepare for this? And how do the franchise zone need to know more about it? How do they plan this? And what sort of pitfalls that they need to be aware about if they don't have these documents in place?
Yeah. So New Zealand is actually unregulated in terms of franchising. So Australia is very regulated. A disclosure document is a mandatory requirement, and there they've got fact sheets you have to provide, you have to update it. So there's a range of penalties, financial penalties. You have to register as a franchisor, a range of things. We do act for a couple of franchisors in Australia, so we're familiar with the requirements there. So New Zealand, a disclosure document is not a requirement, but anyone who's half decent and as a half decent lawyer as a franchisee is going to be asking to see disclosure document. So it's important that you do have that in place because you want good quality franchisees to come on board. And having that is a sign of a good quality system. So disclosure document is just providing some brief information about who's running the franchise system, a 2 to 3 paragraph effectively CV on the commercial background, provide some financial information about the franchise system. A franchisee's going to invest a lot of capital and money. I mean, you're leveraging their capital to grow your brand, so they need to be comfortable, and the advisors, that your brand is financially viable. So some of your financial details are there as a franchisor, and that is updated from time to time. Provides information around other franchisees who are on the system. We talked about churn earlier. So how many franchisees has exited or entered? The ability, if there's any disputes, to list that are there disputes with franchisees. So it's kind of like a good due diligence tool for a franchisee as to this is the head notes, this is what the system's about, who's running it, and a little bit about answering probably most of their questions. You're going to get most of those questions anyway, so you might as well just have it in a disclosure document. So you talked about a confidentiality covenant. So, part of you're going to be, when you're onboarding a franchisee, you're going to be disclosing some information around your system. Some of that information may be sensitive and you don't want your competitors to find out, particularly if there are competitors that have a similar offering and franchisees are shopping around. The last thing you want is a franchisee to say, but look what so-and-so charges as a franchise fee. That's commercially confidential. So a confidentiality covenant makes it clear to a prospective franchisee that the information you're disclosing has to be kept confidential, that they have to destroy it if they don't proceed with the prospect, and they're not allowed to disclose it to anyone else. And it makes it easier if you find out that a prospective franchisee is doing something like that, to go to court to get an injunction if you had to do that. Yeah.
So it's a very important document. I can see that, and what happens, you rightly said that, early stages when people are looking to buy a franchise, then they are shopping around, especially in the industry such as cleaning, or which is like there are so many franchisors in that space. So it's prudent to have those those confidentiality covenants in place so that can protect the franchisors and protecting their the charging or the pricing that they're charging. Otherwise, the competition will actually see that and actually use that for their advantage, which is not good. The other thing is around the sale and purchase agreements, or franchise agreements, which people sign. Is there specific clauses that are needed to protect franchisors from not getting tripped? Is there anything that needs to be in place, either from health and safety point of view or from employment compliance point of view, which is also an issue that we see when franchisees are not complying with the tax rules?
Yeah, very good question. So if a franchisee is looking to sell a franchise business, they need to have a clause in the further terms that provides that the franchisor approves whoever the new franchisee is. That requirement's in the franchise agreement, but it's important that it's again sort of repeated in the actual sale and purchase agreement. We have other provisions or other precedent documents that provide that, for instance, in a lease, some franchisors like holding the actual lease, they call the holder, and they sublease out to the franchisee. There are advantages and disadvantages to that, and in the past, when there's been an economic downturn, a franchisor has sometimes found themselves stuck with a bunch of leases that they really don't want to be part of. And there are ways to sort of mitigate that through setting up separate entities to limit the risk and having the franchisee as a guarantor. Alternatively, if the franchisee is going to hold the lease, we have a precedent lease rider, which is a set of clauses that go into the lease between the landlord and the franchisee, which does give the franchisor the right to sort of step in and pick up the lease if a franchisee is failing for some personal or other reason, and you want to sort of go in as a franchisor and take control of the business and sort of right it to protect your brand. Because if a location closes, it's not good for your brand. And the last one is there's also a provision in employment agreements that with the franchisees employing people, confidentiality covenant, so the employee knows what they're understanding and learning of the system. They can't sort of grab it and use it themselves down the track or share it with anyone else. So again, it's keeping that sort of commercially sensitive information and everything around the system close at hand and protected.
In some cases, what happens is you talked about employee situation. There's some cases what happens is the employees or franchisees they would copy the system and start a competition, their own brands.
Yeah.
How does that protect franchisors? Because IP or the know-how and everything belongs to the franchisors, and somewhere or the other, people try and copy or steal the IP. How does that? What do we do to protect that from a franchisor point of view?
Yeah. So in the franchise agreement, there's a restraint of trade clause. It's been tested in a number of instances, and the New Zealand courts have actually been really good at enforcing restraints. So the starting legal position with generally with the restraints of trade is a restraint of trade is contrary to public policy and unenforceable unless you can display to the court that there's a real need to enforce it. And there's a few things the court looks at. So there's been some cases on that, and the New Zealand courts have actually taken quite a robust approach to enforcing it. They recognise that a franchisor has invested a lot of time and capital in developing a system, and they've got the right to protect that system. So, I mean, if a franchisor, if you let one franchisee just rebrand and do what they want, all the other franchisees will look at it and look at taking the opportunity themselves to do it as well. With any franchise life cycle, When a franchisee is onboarded right at the beginning, they're very excited about it because they're getting all the support from the franchisor. They're learning so much. They're being exposed to the system, the recipe, the secret recipe that the franchisor's developed. Over time, they've now learned what the secret recipe is and how to do it all. But they keep having to pay this 7% or 5% or 3%, whatever it is, to the franchisor, and they sort of lose sight of the importance of running under that brand and the benefit they're having from the system and going, well, I know now how to do this. I want to do it myself. And if you don't have a good franchise agreement that does provide you as a franchisor with restraints of trade and the like, you do run the risk of franchisees going out and copying your system, so you have to shut them down. And those are your tools in your toolbox to shut them down and prevent them from doing that.
Oh,
yeah.
Look, I think that's just quite an amazing sort of, because I've seen in the recent past, there has been a couple of Australian brands, actually one Australian brand that came to New Zealand, set it up, and then they left with the people leaving and starting their own all over the place. And then they had to bring it back to the corporate brand and shut everything down, which is a good learning for everybody to see, how these kind of things can be very, very detrimental for the overall value of the business. Yeah. Now, there's always some people actually ask me this question from the value point of view. So what this is, look, we've already started a franchise business, or we became a franchisor. Nobody advised us how to calculate a value or have a proper royalty sort of mechanism in place. And now we're already 3 years in the system, and we've got everything lumped up in one now, which is our IP sits in the same company, and that's the same company that actually engages as a franchisor to deal with the franchisees. What kind of risk do you see in that?
So there's a lot of trading risk for franchise company or system. We would always advise them to have a company that owns intellectual property, and we would then have another trading company be the company that's licensed by the licensing company to sort of trade with the franchisees. And we would ensure that the name of that company is pretty generic. And the reason behind that is if that company gets into financial trouble, it would be posted in the Government Gazette, XYZ Limited is now placed into liquidation. Whereas if it's Better Foods and that's a franchising brand, Limited, and they're trading as that, there's a risk to their brand. Whereas if it's XYZ Limited, no one will associate that with the brand. And then the license company can simply license a new entity to sort of continue on with the brand. It leaves the brand out of the hands of the liquidators of the trading company, so it means you don't lose everything, so to speak. And often you can pick up, because the franchise agreements would be assets in the instance on the hands of the license company, the trading company. So often you can sort of pick it up from the liquidator at sort of quite a reasonable rate. The other point you talked about with the modelling and having sort of the wrong franchise fee, so to speak, we normally build in our franchise agreements the right to review the terms of the franchise at each renewal. So you'd have to wait until the renewal, but you can then, it's normally phrased at the then current terms of the franchisor, and you would then renew them on the new terms, and they could choose to renew on those new commercial terms or not. But it gives you as a franchisor the option not to be locked in forever on the same terms. I've
seen nowadays there's quite a bit of conversation going on around cartel rules, around competition law. What are your thoughts about that?
There was quite a buzz a number of years ago. It was pre-COVID. So when the Cartels Act came out, about franchisors getting caught up with that. At that point in time, we reviewed our franchisors' franchise agreements and adjusted them as necessary. In essence, the issue sort of came around pricing. So we just make sure that there's no provisions in the franchise agreement that the franchisor necessarily can set the the pricing to a degree, that it is up to the franchisee, and it's very carefully worded in the franchise agreement. And there's sort of one or two other sort of minor provisions that we just had to sort of pare back that weren't really commercially significant for a franchisor anyway. So I would say at the moment it's not an issue in the franchising industry. Everyone's sort of adapted and adjusted and moved forward.
I think that you're right. I think, it was a big buzz a couple of years ago, but it actually faded down, and I've not seen any sort of court cases around that. So, or I've not heard anything which actually went untoward in terms of the New Zealand market. So there was also quite a bit of new news around immigration, and immigration rules are becoming more fair with the franchise industry, which was quite different previously, where a non-franchise business versus franchise business, if they employ people, they were treated differently for visa purposes. I know you're not an expert in immigration, but have you got any thoughts around those new rules? Have you heard about that at all? Or
I've heard about the new rules generally, and we're still sort of looking through the details in it. But what I understand, anyway, the press release from fans on it, so the Franchise Association, is that it is really benefiting franchise systems. Franchise systems are now being treated on an equal footing, which is going to make their lives a lot easier in terms of recruiting staff or employees, which is good.
Fantastic. I think you're right. I think Franchise Association has done a good job in terms of
advocating
that, and the whole board has been really, really active on that. So give them a good credit for that, in terms of what they've achieved in this space. So apart from this New Zealand market that we were talking about, there's also an opportunity for a lot of businesses that are looking to start something in New Zealand, but to also go into Australia. And you touched on that a little bit. So you talked about, how Australian industry or franchise sector is very regulated, and there are specific rules around what you can do, what you can't do. So from a lay person who's starting in New Zealand, but an aspiration to do Australia and New Zealand sort of brand, would you engage and do all the paperwork and prepare franchise agreements for Australia as well, or do you use a lawyer there? How does it work?
We prepare. So we've got precedents, and we prepare franchise agreements in Australia as well. Australia is very regulated, but again, a lot of the regulation best practice franchisors would be following here anyway. So it's not very different in that sense. The mistake we always see is Australians treat New Zealand as just another state. And so when an Australian franchise system enters New Zealand, they go, well, we don't need a New Zealand lawyer to look at our franchise precedent, and kind of off we go. They sort of miss that there's different, let's say, legislative references to, health and safety legislation and everything on this side that they don't have there. So it's not a big job to review an Australian agreement and just ensure it complies with New Zealand laws, but it certainly is worthwhile. They'll also admit when you're looking, the biggest thing behind a franchise is your brand and protecting your brand. So that's like registering a trademark. So if you have aspirations of being on both sides of the ditch, I would say trademarks are not very expensive to register. It does take time. The general principle is first in time is stronger and right. So get in there before someone else does, before they see yours and go, great, maybe I should try register on the other side before they do. I would say register them both. Register in New Zealand, register in Australia when you do set up your systems. If you never end up expanding that side, maybe it's a couple of $1,000s you kind of waste. But if you do use it and someone else has got something sort of similar there, and you were too late, you'll always regret it.
No, I think you're right. I think, and there has been some cases like that which I've come across recently, where the website was quite similar in terms of what we had in New Zealand and Australia, and it was a task to go through to get that sort of domain back to this person who was looking to do that, or looking to open offices or businesses in Australia. So there are some prickly issues that can come in like that. I've seen that from a practical point of view. One more thing that we do very closely with the clients, preparing this area mapping, where client would come along and say, look, we want to, say for example, we recently did a pizza company, right? So we developed the whole system, and they came along and said, we want to do an area mapping for New Zealand, and want to understand which street we can start our particular outlets. And the factors that they looked at was the population, the earning capacity in that area, what kind of ethnicity they were dealing with, so these are the 3 or 4 factors that they considered, right? So we did that area mapping. We get a tool from overseas, which actually gives us a good GIS mapping, and also with the help of Statistics New Zealand, we actually do get some data, for New Zealand, which is quite relevant. Once we do all that, there's always a question that comes up: is that the area splitting, which is normally a radius of say 5 kilometers. Just an example I'm giving you.
Yeah.
But there is an overlap sometimes, and that initially when you're selling it, you don't have a problem. But sometimes a brand actually, is very successful, and there is an overlapping that needs to be done. So what kind of things that we need to have in a franchise agreements that can protect that, even though if you say 5 kilometer radius, but how do you prepare? How do we deal with this overlapping situation?
Yeah, very good question. So territories is a very contentious thing. And you can get an exclusive territory and a non-exclusive territory, depending on the type of business or system. Sometimes you have non-exclusive. So there are real estate agencies out there where they have non-exclusive, so you could set up under that brand virtually anywhere. And then you have systems where there are exclusive and sort of set territories and boundaries, and sort of anywhere in between. What we do, we have to word it very carefully, is we build the ability for a franchisor to split a territory. So population increases, like you say, that brand recognition in the area gets to a point of saturation where one franchisee simply can't service everybody. So the brand is losing out. So the way we normally word it is to say, in a nutshell, if the franchisor acting reasonably determines that one franchisee can't quite service that whole territory, that the franchisor's got the right to split it. They will give the franchisee the first option to purchase the new territory created, and that's sort of the middle ground of you're not just sort of dictating from high as a franchisor. But if they don't take it up, then the franchisor can offer it to someone else. So that's a nice way, but that's a way we find kind of gets over the line with most franchisees solicitors, just simply saying we can in our discretion split the territory and cut yours down and hand some to someone else doesn't sit that well. So again, it's something that can be a bit contentious. You can have, like you say, you can service clients outside your territory and other people's territories, but you can't market in their territories. So there are different ways to deal with the activities a franchisee can do within their territory and outside their territory to allow some kind of overlap of trading, because it can be artificial. Like there's a franchise system that deals with property management. So the same thing, they have their territories, they can service properties outside their territories because it's through people they know or whatever, but they can't market themselves outside their own territories.
Yeah, that's a very good example that you gave, because I was actually thinking about property management in my head, and I was thinking also about an after-school care franchise, which has a similar issue in the past, where there were people who were outside their territory. The kids wanted to come along, and there was a confusion around who will have that sort of kid, even though they are from my area, they're going to another area. So that's one thing that's really nicely answered there. Thank you. I think overall we've achieved quite a bit today in terms of franchise, setting up franchise, the legal issues, the accounting side of it, valuing and then the other factor that comes in is always the finance of the franchise, which you're not an expert in that, so I understand that. But the finance company, the bankers would get involved and want to see the documentation and systems and all that. And I've seen that from my experiences that the experienced bankers who specialize in franchise would know between a good franchise system and not so good franchise system, not only based on numbers that they've got in front of them, which is the KPIs and everything else, but more so also the documentation or who prepared the legal documents. So that becomes an important factor, in terms of getting further funding to run the business. So I think there are more to discuss. I think this is just a part one of a conversation that we're doing, and see what the response is. Once we go out there and put this online and see what sort of questions we get. And I think I'd love to have another chat with you, or part two of this conversation, which can take it further, more in detail about franchising, about a specific thing or specific case studies we can talk about. I've got a few that I can raise it, and then I'm sure you'll have some war stories to discuss as well. So any final points that you have that you want to raise?
Well, I think I just want to say that there's some very good franchise systems out there. Franchising can be a very rewarding way to use someone else or franchisees to leverage and grow your brand, use their capital and use their energy. There's difference to employing a manager versus employing someone who is not an independent contractor, but are working on the same basis. They know if they don't sort of put the time and effort in, they're not going to get paid, not a salaried employee. So it can work really, really well. Yeah.
Like kind of the skin in the game sort of thing.
Yeah, absolutely. Yeah.
Yeah. Look, just want to say thank you, Alistair. It's fantastic. It's been great. We spoke for almost an hour today. The time just flies, We actually covered quite a bit.